DHA attorneys that are waiting on their paperwork. Are they on the line as well? Listening?
I believe so, Your Honor, and good afternoon.
Good afternoon. And then show the presence of Mr. Gaona, who was here the other day on the first case that I did this week, and you represent Ms. Hobbs, is that correct?
Your Honor, that's correct. I'm here today and along with Bo Duell with States United Democracy Center on behalf of Secretary Hobbs in her official capacity as Secretary of State. And I do want to note for the record, Your Honor, that we are specially appearing today without waiving any defenses of any kind because this case, the complaint in this case has not been served. And that's a topic I imagine we'll address in a few moments here.
And people are wanting to get in. Is the Mr. Heath, is the plaintiff on the line too, Mr. Borrelli?
Mr. Borrelli is actually out of country, Your Honor.
All right, so you're waiving his presence today. All right, and so I see Ms. Danneman, who do you represent?
Hi, Your Honor. I represent the governor-elect, Katie Hobbs, in her personal capacity.
All right, so are we missing?
And Your Honor, I would also like to note for the record that we are specially appearing here as well. We have not been served and we will not be waiving any defenses as to, our personal jurisdiction.
All right, and I guess I assume some of that might be coming here today, and we'll deal with that. This is set for return hearing, and Mr. Heath, is there anybody representing as a whole the Board of Supervisors for Maricopa County?
Your Honor, this is Andy Gaona. I do not see anybody from the county on here. I do know that as of 4 p.m. today, they also still had not been served with anything.
All right, I guess, Mr. Heath, let's start with that. If we're going to schedule, we have to get everybody into the case that needs to be into the case. So what is your position today on what we need to do? These are such interesting cases, have to be done quickly. This have to be, I set this hearing, I received the complaint or the petition for an order to show cause on Monday of this week and set it for today. And where are you at on this, and what is your position on the people that haven't been served not being here, and where we're going?
Well, Your Honor, I would say that co-counsel right now is actually handling service of process. That wasn't something that was assigned to me, but we will be having that effectuated here in the coming days. So I wouldn't worry too much about that.
Well, do we need to set another hearing, or do you want to, I guess I'll hear from the other counsel, Mr. Gaona. Some people aren't even here to participate in the scheduling because they haven't been served. What is your position on that?
Your Honor, the suggestion that it's not a problem that service has not been affected in this expedited election contest is frankly ridiculous. This complaint was filed on Monday. The only reason that the Secretary's office became aware of the fact that this complaint had been filed was because it was being spoken about on social media and appeared on the CNS report, that proprietary email that lots of firms get. The only reason that I found out that there was a return hearing at all today is because a reporter sent me a copy of the order. And so I'm here out of respect for this court, and because I appear in front of this court often, and felt it was important that the Secretary appear here in her official capacity to note the issues with this case. But Your Honor, our position is that the plaintiff has failed to comply with the election contest statutes. This court has no personal jurisdiction currently over any of the defendants. Has been a failure, an indisputed failure to prosecute this case diligently by serving it, given the tight statutory deadlines that the court just identified. And the Secretary believes that this case should be dismissed based on laches grounds, failure to prosecute, failure to serve, and a failure to diligently prosecute.
Thank you, Mr. Gaona. Ms. Danneman, do you want to be heard on that as well?
Yes, Your Honor. The governor-elect agrees. We have not been served in this matter. This court has 10 days to hear the matter. Time is running. So we would also move to dismiss this matter immediately based on failure to prosecute.
And Your Honor, if I could just say one more thing, I'm sorry I neglected it, which is that not only have we not been served, but Mr. Heath's office appears to be not too far from my own. No one ever picked up the phone. No one sent an email. No one did anything to even try to effectuate service through alternative means. This is, Your Honor handles election cases all the time, and the court knows that this is not how these cases are normally handled. And so I would just reiterate my request with those additional facts.
Your Honor, if I may respond. Very
Yeah,
briefly.
obviously, that's what I was getting to next, Mr. Heath. Go ahead.
Yeah, so the summons here automatically were produced by Turbo Court with a 20-day response for the answer. That's what the summons initially indicated. And as Your Honor is likely aware, there's been some back and forth through email to actually fix that with Your Honor's court. And so we actually had the summons fixed yesterday with the help of the Mohave County Court. And it does now reflect a 5-day answer requirement as required by statute. And that's the reason for the delay, Your Honor.
Well, I will tell you, I went back and looked at the summons for the other hearing. As you may know, Mr. Heath, I don't know, Mr. Gaona knows because he was here, but I have 2 election cases pending before me currently. And I went back and looked at those summonses, and they all had the 20-day, but they got issued and served right away. And then you can address the time for the answer. It's set for return hearing quickly. And I don't know why those summons weren't issued immediately. If that's the only reason, I would just tell you for the record that they were issued in the other case immediately, and the other party showed up at the return hearing.
Yes, Your Honor, I understand that. We were operating under the impression of the statute 16675, which prescribes the way that summons are supposed to be issued in these types of election cases. It specifically actually has a form for the court to follow when issuing a summons, which requires a 5-day answer, which is why we reached out to the court to rectify the original 20-day summons issued automatically by Turbo Court. We wanted to ensure a timely response for our client here, which is what we believe is necessary.
I guess, Mr. Heath, are you alleging a court mistake or that's the summons that we issued in all these cases, and maybe we need to create a new summons, or you didn't provide us with a specific summons?
Actually, yesterday, Your Honor, I was sending a summons to the court with the correct language. I sent it via email to Megan. Excuse me, I can find the name if you'll give me a minute.
I know her name, Megan Vigil, Vigil.
Yes, Your Honor. And that was to correct the automatic production of a summons indicating a 20-day time to respond. We want to make sure that the defendants in this case are held to account within the statutory timeframes prescribed by law.
Ms. Danneman, you were about to say something?
Yes, Your Honor, if I may be heard. I mean, I think regardless of what happened, that the effect has been highly prejudicial to the governor-elect and the other defendants. These matters all have a 10-day time frame for hearing, and the plaintiffs have simply waited too long.
Mr. Gaona, do you want a final word?
Your Honor, I would echo what Ms. Danneman says. The election contests, as the court knows, are creatures of statute. They are required to happen in an expedited period of time. There was no reason for the plaintiffs to wait until they did to file. There was certainly no reason for them to not even attempt service or not reach out to counsel that they know represents the defendants. At this point in time, we are treading dangerously upon the constitutional deadlines for the orderly transition of power. Arizonans deserve finality with respect to this election, and that the simple fact of the matter is that the plaintiffs have not diligently prosecuted this case, and it should be dismissed now as a result, so as not to take up any more of either the party's time or the court's time.
I certainly would, in theory, don't they have, I mean, can't I set another hearing within 10 days of when they filed it and they get the summons is done? Obviously, they may have to change them again. I don't know, have specific dates, but the summonses they're sending out that haven't got to anybody would be for today's date, and nobody showed up for today's date. And I don't know if it's even worthwhile extending the deadline or creating a new date for this. Don't they have, if they file this on Monday, don't they have until Wednesday of next week or Thursday?
Your Honor.
Ms. Daneman.
Thank you. The governor-elect's position is that the hearing on the contest must be within 10 days, which is, I think, next Thursday. So at this point, the whole briefing schedule does not make sense given the delay.
And Your Honor, I would just add, if I may, that a defect in the number of days that appears on a summons appears to me to be nothing more than a post hoc excuse for the failure to prosecute this case. There was nothing stopping the service of that summons. There was nothing stopping the service of the order to appear, which would have gotten all the parties before the court today, and we don't have the county here because they were never served. This is a fundamental failure on the part of the plaintiffs to comply with the election contest statutes and to serve it within a reasonable time. And here we have to judge reasonableness within the context of the statutory scheme. At this point, a day may as well be a week if we're looking at this from that level. And as a practical matter, Your Honor, there is no way to resolve this case anymore. The plaintiffs have lost their opportunity to have their contest heard. I would note that we don't think there's any merit to their contest and that it was filed too late anyways, but we don't have to get there, and that the case should be dismissed now.
Your Honor, if I may respond.
You get the final word, Mr. Heath.
Yeah, the timelines here are set forth in 16.676, Your Honor. And it very specifically explains that there are timelines, which we are still well within. We wanted to make sure that everything was perfect with respect to the summons. We want to make sure that the defendants here were held to account within the timelines required by law for them to file an answer. And there is actually permissiveness in 16.676 for the court to file a 5-day extension for that initial 10-day period, as well as the fact that we are bringing constitutional challenges here, Your Honor. It's a bit ironic to hear defense counsel claiming that the Constitution requires a peaceful transition of power. That, in fact, is not the case. There is direct precedent quoted in our complaint explaining that expedited hearings or the desire for an expedited resolution is no excuse for violating the constitutional rights of the electors. And that's exactly what we're arguing here. This is a matter of, frankly, such importance that even if there was a constitutional transfer of power, Your Honor would be completely justified, as has been done in multiple cases in the past in Arizona history, going back to 1917, and actually removing the governor-elect from office, which is what we would request this court to do if we got to pass that deadline.
Well, I guess my problem, Mr. Heath, is we're having a hearing without everybody here. The two people that are here did not get served, and they have made special appearances only because it would have been just you and me sitting here talking if they hadn't have showed up. This is a case that you have some special duties on if you're going to pursue. And I get your argument that we can go beyond the new year and you can have a transition of power and then untransition if I eventually found for you. And maybe that's a lawsuit that would be a full lawsuit that would take a couple of years, like some of these other lawsuits that I do all the time. This case is under the election rules, which you've cited, and it does allow to extend another 5 days to possibly set a hearing. But we have to have service and get people in here. And your unwillingness to send out the original summons has kind of delayed this process. Here we are a week before Christmas, 2 weeks before the governor takes her position in office. I know there's other cases pending that are dealing with these issues as well. The court's position is difficult. I can't proceed without everybody here. And since you filed this case, somebody else has just signed up. Cameron Powell, are you one of the Pro Hoc Vice attorneys, correct?
That's right, Your Honor.
And I'll just let you appear as a special attorney. For some reason you have something causing an echo. Do you have something else on in your house or something? Now you're on mute, but you had an echo when you were off mute. If you have another line on or,
Can you hear me now?
yes, and without
Yep.
echo, that's, yeah.
Yeah, I just wanted to, again, I'm not formally.
Now we can't see you. We could see you a second ago.
Yeah. And Your Honor, if Mr. Powell's not admitted pro hoc vice, I don't know why he should be permitted to address the court.
And I agree with that, Mr. Gayon. I'm just going to let him address the court. I know that he's not admitted, and I'll take it for what it's worth. I just wanted him to at least explain. Mr. Heath started this whole thing saying somebody else was in charge of service, and that must have been Mr. Powell. So go ahead and speak, Mr. Powell. And I understand Mr. Gayon, and I'm sure Ms. Danneman's objection to you speaking. And you're not yet admitted into the state of Arizona, but I think it's just a technicality we're going to get through at some point. But go ahead and speak.
Granted, okay, thank you. Thank you. The only point I was going to add to what Mr. Heath said is that the action here is not just a special election contest. We have equal protection claims that could seek prospective relief and don't require this kind of rocket docket treatment as well. So at the very least, I'd ask for more time to look at those prospective forms of relief, the forms that don't involve unseating a governor, but do involve perhaps changing some of the policies and procedures of Maricopa, perhaps even Arizona state law, and that are not part of this special elections contest with all of its speed that's necessitated by that.
Your Honor, may I be heard in response to that?
Yeah, thank you, Mr. Powell. Go ahead, Mr. Gayon.
Your Honor, if to the extent that the plaintiffs want to seek prospective relief and they think there's a problem with how Maricopa County verifies its signatures and they want to seek relief prospectively, then they should voluntarily dismiss their election contest claims today, and the case could proceed on a normal schedule if they wish to have this court hear them, and they could be heard in the normal course, as Mr. Powell just mentioned. We're here today on this extremely expedited basis because they have pled election contest claims that have to be resolved in that way. So a very simple way to resolve the urgency of this issue and to give plaintiffs their day in court on their claims about signature verification in Maricopa County. And we can have another discussion another day about why we're having that discussion, about why we're having that argument in this particular forum. But the easy answer is for plaintiffs to agree today simply to voluntarily dismiss their election contest claims and to allow their other claims to proceed as on the normal course.
I kind of thought that's kind of what he was asking me to do, Mr. Danneman. I mean,
Yeah.
I apologize, Ms. Danneman. That's
No worries, Your Honor. I agree with Mr. Gayon, and I would also request that to the extent the contest claim is dismissed, then the governor-elect in her personal capacity would also be dismissed as a defendant because there would be no jurisdiction over her.
all right. Mr. Heath.
Yes, Your Honor. I would just simply point back to the statute of 16676 at this point. There is a 10-day window within which we are still well within. We had an issue with the summons. We did our best to correct that with the court. We received the summons back yesterday from the court, the actual correct summons, which requires a response within 5 days, which is what we anticipated. We did not want counsel pushing this back over and over again, which we believe would happen if we waited or if we allowed for the 20-day window to file an answer. And what's important here, I believe, is that the court has the capacity to extend 5 days per 16676A. And because we were waiting on the court to help us, we actually, I believe the email communications with the court about the summons issue started immediately the day after, or at least Wednesday of this week. So it was just a few days ago. Again, this was filed Monday of this week, and we have been working diligently to try and get that summons fixed to get that out. I believe that we can very easily serve defendants in this case on Monday, and we can move forward. In fact, I believe that Maricopa County had full knowledge of everything here, given that they have publicly responded, at least a few of the defendants like Mr. Riker, for example, and have made public statements about this case. There's no prejudice here, Your Honor. They are fully aware of everything that's been going on and are capable of responding. And this is the state, and this is a few individuals that have a stake in this, and they have virtually unlimited resources, it seems, to respond. So they should be able to get back to us within the time allotted by the statutes, Your Honor.
And Your Honor, just one clarification on what the statutes actually requires. ARS 16676A says the hearing has to be held within 10 days from filing, not from service. And the court's ability to extend that by 5 days is for good cause shown. And I would respectfully submit, Your Honor, that the plaintiff sitting on this complaint, doing nothing about it, making no attempt to serve it, and then, being fortunate enough that two of the defendants happened to show up at an order to appear at a return hearing, rather, for which the order to appear was never served, is not good cause.
Your Honor, we would have served this sooner had the summons been correct. That was the delay. There was no issue apart from that.
I guess, Mr. Heath, when you said that they would delay things, it's been my experience in these cases that and Mr. Gano just did this the other day, received a summons that said 20 days, showed up, filed a motion, agreed to trial dates or actual hearing dates. In that case, didn't slow play, and that's what happened, I believe, in other court cases in the state dealing with the same thing. These people are showing up, and if they get served properly, even with a summons, even if it had the wrong amount of days to file an answer, they did show up and they did participate, and they did participate in good faith to try to get this case, that case done in timely manner, and they would have done so in this case. And you said it during your last argument that you're worried about them slow playing because the requirement of a 20-day answer in your summons. That's not what would have happened. So I guess I'm just suggesting that was a mistake on your part to think that's what would have happened if you would have filed the original summons that you did have on Monday, or at least by Tuesday. I think I decided on Tuesday morning what day I was going to set this hearing, and we sent that notice to you that morning. These are difficult to do. This is like herding cats. This isn't simple stuff on all the parties. I do believe that Mr. Powell had a point, and Mr. Ganoa and Ms. Danneman has a point. This is about the system and whether or not this county should hear it. That'll be for another day. But this is about the system of voting that you're alleging is completely wrong. I would have and was going to say at some point, even if this case were to go forward, this is a case that would require expert testimony and expert analysis from both sides for me to be able to make any determinations. I was an accounting major when I first started college back in '78, but I've been a lawyer too long to remember anything to do with numbers, and certainly wouldn't know what I'm about to call it virtual intelligence, artificial intelligence is, and how it works, unless I was had a lot of things to review and read. So the bottom line is I believe this case cannot go forward based on the lack of service prior to today's return hearing, which I said as quickly as I could. I'm actually, I know I've made this record, I'm actually off next week. I've set hearings and cases next week that I have to come to, even though I don't want to on my days off, but I'll come to those if those hearings take place. I'll be here Monday, but I don't even have these people served in this case yet. And you're asking me to continue and extend these hearings. I don't have the time to make that happen. It is ordered dismissing the elections portion of the contesting of the elections portion of this case for lack of service. I'm gonna allow you to get service on the remaining portion of this case, and we'll deal with those. We'll treat this as a normal civil case as we go forward. I don't know if that means you're gonna have to amend the complaint or something, but that portion of the case is excised from the case, the election, the actual contesting of the election in Maricopa County. That does remove Governor-elect Hobbs in that capacity. It doesn't remove her in the other capacity, I believe, yet. But that's what that's what I'm ruling today. The contesting of the election portion of this case is removed. You get your service, and then answers can be filed, and maybe the original summons is better now because 20 days normally for a regular civil case. That'll give time for Mr. Powell and the other parties to get their pro hoc vice, the other attorneys, and then we can argue whether or not that's a legitimate case. But I'm finding specifically that we cannot process a contested election case in this matter because of the lack of service I had set this in my mind as the last possible date to find some dates to do discovery, what limited discovery can be done in this type of case and get this done before the end of the year. And that's no longer possible. So I'm removing the contested election portion of the case from this case, and we'll just deal forward with the actual issue of the artificial intelligence and all the other things that have been raised.
I understand, Your Honor.
right.
I appreciate your perspective.
All right, that may require going back to the old summons or issuing the original summons, but we don't have a date. That would the rules would then apply. The civil rules, Rule 16, would apply. But this case is no longer an contested election case. All right. Anything else today, Mr. Heath?
Not at the moment, Your Honor. We appreciate your time today. Thank you. And I'll get with co-counsel, and I'm sure we'll be filing a few things here shortly.
All right, thank you. Anything else, Mr. Gayona?
No, Your Honor. Thank you for your time on a Friday afternoon, and I hope you have a nice weekend.
All right, anything else, Ms. Daneman?
No, Your Honor. Thank you so much for your time.
My son and I are going to a bowl game tomorrow up in Vegas, so that'll be fun. The Gators are playing. All right.